Federal statute says a pattern of racketeering activity requires at least 2 acts of racketeering activity. Oh, so doing it twice is enough. Or sending 2 emails as part of one transaction is enough. One of which occurred after the effective date of this law, and the last of which occurred within 10 years, excluding any period of imprisonment if they, in case you weren't out here doing it. So after the commission of a prior act of racketeering activity. In other words, we'll exclude the time you're in jail if you did 1 act of racketeering activity and you were on vacation for a while at government expense and then came back. We'll adjust the time. So that's the federal definition. The state definition is pattern of racketeering activity means engaging in at least 2 acts of racketeering activity, which are related to the conduct of the enterprise. At least one of such acts occurred in this state, that's why it's a state act, after July 1, 1981. Every state's a little different. And if the last of such acts occurred within 10 years, again, excluding any period of imprisonment, after a prior act of racketeering activity. So now we heard the word enterprise. So what's an enterprise? Because what is illegal is to commit these acts as part of a pattern of racketeering activity. And people usually do it through or in connection with an enterprise. An enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. Oh. Well, it's also illegal under these acts to engage in a conspiracy to violate these acts. So a conspiracy in general terms means an agreement between 2 or more people to commit an illegal act. And that's one of the broader definitions. And so we can get people who don't look like they're all part of the same organization, but because they act in concert with each other to a common end, or they have benefits or a variety of relationships with each other, we say you're part of an enterprise designed to rip people off through performing these predicate acts. That's what we call this whole list of violations I've been discussing. They're called predicate acts. One of the fun parts of assembling and prosecuting one of these cases is that the plaintiff and the prosecution has great leeway in how they define the enterprise, because it's often not clear in the beginning and it takes a lot of discovery, and there's very liberal discovery because of the nature of the claims and the nature of the factual inquiry.